You had some drinks, you were driving home, you got pulled over, you blew over the legal limit and were placed under arrest for drunk driving. What possible defenses are there? What can a top-rated DUI firm do for you now? It turns out there may be a lot. First, you need to understand that there are potentially dozens of pages of police reports, witness statements, 911 calls, in addition to dash camera videos taken from the squad car and body camera video taken from one or more of the officers at the scene. There will additionally be reports from the chemical test, whether you blew into the intoximeter back at the station or if you had a blood draw. These reports and videos will reveal a tremendous amount of detail about exactly what happened during the stop to form a specific evidentiary picture for us attorneys to draw on. But wait, you were driving in over the legal limit. Why do any of these details matter? The short answer is that both law enforcement officers and the courts must follow the law that is grounded in the Constitution of the United States. According to the Constitution and the Bill of Rights, officers cannot unreasonably detain someone. Furthermore, all arrests to be legal require two words: probable cause. Without probable cause, that test score showing that you were over 0.08 disappears from the case. So how do we know if the officer had probable cause? NHTSA. This means the National Highway Traffic Safety Administration. This is the government group that wrote the rule book for law enforcement on how they are supposed to investigate and arrest drivers for operating while under the influence. NHTSA created some important clues for intoxication that officers are trained to look for during the 3 phases of the traffic stop. NHTSA also is the organization that wrote the very detailed rulebook for how field sobriety tests are to be explained, administered, and graded. NHTSA makes it clear that a failure to properly administer the field sobriety tests may completely destroy the value of the results, to the point where they can no longer be relied upon in court. No results can mean no probable cause. No probable cause can mean no case. This may remind you of when you were in school, you were solving a math or chemistry question. If you messed up your work, did you get the right answer? Of course not. It is the same way with these tests and the investigation. If the officer does not follow NHTSA's strict standards, then NHTSA itself says that we may not be able to trust the test's conclusions. The bottom line, if the officer messed up and failed to follow their own training standards, this may result in a collapse of the case against you, potentially even leading to a dismissal or reduction of the charges. So how do we know if the officer followed the rules in your case? This is where these police reports and videos will give us many of the answers. Your recollection of the night is crucial to assist in your defense, but the recordings and police reports are also critical in grading whether law enforcement followed the rules of how they were trained. Lastly, even if the officer did fail to follow the training standards, do you think it will mean all that much if you were stumbling around blind drunk? Almost certainly not. It will only matter if you were not impaired and are acting reasonably under the circumstances, regardless of whether or not you were over or under the 0.08 limit. Keep this in mind. This discussion is highlighting a single area of possible defenses in your drunk driving case. There are dozens upon dozens of other important issues surrounding whether the stop was legal, the various detainers that the officer used throughout the stop and whether they were legal, the informing the accused paperwork that was read prior to the chemical test, whether the blood draw was legal and properly done, same thing for the breath test, and whether or not the correct people with the correct training and equipment administered it, among many other issues that could also lead to a dismissal of your OWI charge. I'm only talking very briefly about NHTSA because these are some of the best and most proven methods of handling OWI cases here at Wisconsin's most successful, not to mention largest drunk driving and criminal defense firm, Breeve Law. The bottom line, and what I want you to take away from this video is this: these cases and their outcomes hinge on essential small details. These details are impossible to find without a high degree of sophisticated and ongoing training and experience in drunk driving law. They are also useless without the proper knowledge of how to implement them in the courtroom to maximum effect. Most so-called defense lawyers are general practice attorneys who never received the proper training in NHTSA, and their track records show it. Our top-rated team of former state prosecutors and dedicated defense attorneys have all gone through the same NHTSA training and passed the same test that the officers who arrested you did. We additionally have the attorneys on staff who have gone through the advanced instructor training and are capable of educating the officers about what they did wrong in your case in court. Contact our office to learn more about what defenses might be available in your case with a free case consultation. Our friendly team of veteran attorneys will chat with you about your case, what you are facing, the court process, and we will do our best to answer your questions, keeping in mind that we have very limited information. Also, be sure to check out our other great content about ignition interlock devices, operating after revocation charges, administrative review hearings, and much more. Thanks for watching, and I look forward to chatting.